Good morning, everyone. I'm Scott Hayslip, NAA's Vice President of Legal Affairs. I wanted to thank everyone for attending this important webinar this morning, co-hosted by NAA and Womble Bond Dickinson. As we all know, the coronavirus has greatly impacted most industries, including the multifamily industry. In efforts to mitigate the economic damage caused by the virus, the federal government has enacted a number of laws and programs. One such key program is the Paycheck Protection Program. Today, NAA is happy to bring you three of Womble's experts on this topic. And with that, I will hand it over to Mark. So Mark, if you could introduce yourself and your team, we'll get started.
Great. Thank you, Scott. I appreciate it. My name is Mark Henriquez. I am co-chair of Womble Bond Dickinson's COVID-19 task force, and we're pleased to talk to you today about the Paycheck Protection Program and the CARES Act. I know you've had a number of questions. We'll try to answer those here, and we'll try to answer those as we go in the webinar as well. I do have two other folks that are presenting with me as well. And let me give you a few reminders before I introduce them. This is being recorded, and the slides and recording will be available on your website, naahq.org. You'll get a notice for that when the presentation is available for download. Some of you have already started typing in questions in the Q&A box. I encourage you to do that. We will get to as many of those as we can. We may also have to provide an FAQ sheet at the end. I know there are a lot of questions around this. We have set up a dedicated email within our firm for COVID-19 questions. You can do, you see that on the screen, WBDUS COVID-19 at wbd-us.com. Or if you've worked with a Womble attorney, we are a large firm. We've got over 500 lawyers here in the US and other 500 in the UK. Feel free to contact your contact person there, and I'll show you some of the multifamily folks at the end as well. So. For today, again, my name is Mark Henriquez. I'm a co-chair of the task force. We've got Stephanie Few, a partner in our Charleston, South Carolina office, as well as Sarah Wilk. Stephanie and Sarah have done a lot of work on understanding the PPP loan program, and I'm going to be moderating the discussion as we get into it today. But happy to answer your questions. I did want to start with some basics, and I like to start before I dig in to say I understand that COVID-19 is first and foremost a health crisis. We're going to be talking a lot about money and applying for money and the economics, and that's obviously important, but certainly our thoughts and prayers go out to those that have been infected or know people that are infected. It certainly had a major impact on landlords throughout the country. You know, everything from having to close facilities like pools and gyms and common rooms to the fact that many tenants are unable to pay rent because they've lost jobs or have been furloughed or had their pay reduced. I know many of you have done, you know, rent forgiveness programs or rent abatement for people that are suffering the effects of COVID-19, and that's very much appreciated. But everyone understands that there's a significant impact, and it's magnified by the fact that foreclosures are now limited in many jurisdictions, either because the courts themselves are closed or there are moratoriums in place. So it's having a major economic impact on landlords, ranging from the small landlord who owns just a couple of houses to very large landlords with hundreds of buildings and thousands of tenants. And we understand that economic impact, and I think that the loan programs we're talking about today are one of the ways to potentially mitigate some of that impact. So what is this Paycheck Protection Program loan? Again, the CARES Act was the really big legislation. There was the Families First Act that was passed first that dealt with specific things around sick leave, but this was adopted on March 27th. It adopted a number of things. The CARES Act is also the congressional act that's putting money into individual pockets. You know, people that make under a certain income limit are going to get $1,200 a person, but it set aside a lot of money, $349 billion for a new loan program to small businesses. And it's under the Small Business Administration, but as we'll talk about, it's administered by banks, and it's open to a lot of businesses, and there's a lot of confusion around who can apply. So we're going to dig in to some of that detail in just a moment as we get started. I did want to, before we dive into the details of the PPP and what it is and how to apply, I wanted to remind everybody on the call that this is not the only relief that is available. And so there are three other things that I wanted to talk to you briefly about. Please understand, you could do a webinar on each of these, so this is not going to be the full and complete answer on any of these, but there are economic injury disaster loans. And these are available for small businesses and nonprofits. It is a loan. It doesn't have a forgiveness component. That's an important distinction between it and the PPP, which we'll be talking about today. It's also capped at 2 million instead of 10 million, and the interest rates tend to be higher, 3.7%, 3.75% for small businesses. That's more than the 1% we're seeing under the PPP. It also requires personal guarantees. So generally, I think most people view the terms of the EIDL as less favorable than the PPP loan program, but it is another option that is out there. The option you see at the middle of the screen is less defined, but there is money set aside. $500 billion, $500 billion is targeted at distressed sectors. Some of that is earmarked for transportation and the airlines particularly, but there's expected to be additional money for other large businesses that are impacted. There are several restrictions around stock buybacks and capital distributions, but particularly for publicly held companies, and there are some of you that may be on this call, that may be an option for funds, and that is still really the rules around that. It's going to be administered by under Treasury are still in process, so there's a bit of a stay tuned for large businesses, but if you don't qualify for PPP, that's an option. And then the third item on the screen are tax credits and deferrals. As many of you know, the income tax deadlines have been pushed back to July 15th, as well as any required payments. You can also defer payroll taxes, the employer portion to 2021 and 2022, if you do not take a PPP loan. So if you don't qualify or decide not to take the loan we're going to be talking about today, deferral of payroll taxes is an option. And then very importantly, there's a employee retention tax credit, 50% of amounts up to $10,000 per employee on wages you pay between now, actually going back to March, and the end of the year if your business was suspended due to COVID-19 or you had a 50% drop in revenue. So that's worth talking about, particularly if you decide you can't qualify under the PPP loans. That is real money in the form of a tax credit that may be available. So, and then that's something we've been talking to some of our landlord clients about, are the tax credits, if for a variety of reasons they're not going to be eligible under PPP. So with that in mind, let's go ahead and turn to the PPP itself and start with the question that I know we've gotten a lot of questions about, which is who can be a borrower? And Stephanie, I'm going to call on you here, and maybe you can help us walk through some of the requirements around being a borrower under the PPP plan. Or actually, and actually, it may be that Sarah, can you? I may have called on the wrong person. Sarah, do you want to talk a little bit about the borrowers?
Yeah, I'm happy to, Mark. And it looks to me like Stephanie may have gotten dropped off, so hopefully she can rejoin at some point. But who can be a borrower? There's been a lot of questions that have come up about this. And unfortunately, there are still questions that remain outstanding. This program was enacted so quickly, and everyone's goal is to get money into people's pockets so that jobs are maintained and people are able to continue their normal lives as much as possible while this crisis is going on. So, everybody's doing their best to understand this on a very quick timeline and get money into people's pockets as soon as possible. So bear with us as there are still some open questions, but so generally, who can be a borrower? Businesses have to have been in operation as of February 15th of this year and either had employees or have been independent contractors at that time. Independent contractors are separately eligible to apply for a PPP loan. And then there's several buckets of businesses. So small business concerns, as defined in the Small Business Act, can be borrowers under this program. That is defined in several ways. One is just based on an employee count. Another is based on revenue. And then there's an alternative test based on tangible net worth and net income. And that all of those kind of tie back to an NAICS code that each business has. So there's not, we can't give it, the numbers because they vary across industries, but that's one way to be eligible. The most common way that we have had our clients be eligible is any businesses that have 500 or fewer employees in the US is the big test here. Also includes 501c3 nonprofits, veterans organizations, and tribal business concerns under that prong, but those are a little bit less common. And so then we get into, who do you count as your employees to get to that 500 or fewer number? You have to include both full-time and part-time employees in that count. There's has been a lot of uncertainty about whether 1099 independent contractors that work for businesses are included in that employee number or not. The general consensus seems to be that they are not. And there's been some guidance that has come out from Treasury and the SBA to say that those contractors should not be included as an employee for their business because they are, again, separately eligible on their own to apply for these loans. So that seems to have been answered, but it kind of depends on the facts of each business, whether those 1099s get counted or not. And then there's also a lot of uncertainty, especially for venture capital and private equity backed companies, about whether affiliates have to be included in the count. So for the normal SBA loan programs, affiliates are consolidated with the applicant so that all of the employees of a business and its affiliates are counted. There is some information on the PPP where those affiliate standards do not apply, and we'll get into that in a lot more detail in the next couple slides.
Yeah, no, I know we're gonna dig into that. I think it is important here before we advance, so to remind everybody on the call that you don't have to meet the other definition of small business if you have less than 500 employees. So I think there's some confusion around this because people hear about it as being, for small businesses. There are some businesses that are very large that have less than 500 employees, and those businesses are going to be eligible for this if they meet the other criteria. So that's an important provision for everyone to remember. All right, so let's talk about some of the other ways you can qualify. And this first one is really one that applies even if you have more than 500 employees. Go ahead, Sarah. Talk to us a little bit about some of these provisions here.
Yeah, sure. So some businesses, depending on their NAICS code, may be allowed to have more than 500 employees if their industry standard under the SBA regulations has a size standard that's greater than 500. So for some NAICS codes, there's, you can have up to 1,500 employees. So really need to just check on your NAICS code and make sure that you're not missing out because you have a greater employee size standard to meet there. Don't have to spend a lot of time on that next bullet, but it's basically any food services or hospitalities, restaurants, hotels, that kind of stuff with a code of 72 can employ 500 employees per location if they have multiple locations and still be qualified. And then, as I said before, independent contractors, sole proprietors, and self-employed individuals are also eligible.
Great. Now, I understand that there are some folks that appear to be ineligible for SBA loans, and I know some of these may affect some of our listeners here. So let's go through the list, and then we'll talk specifically about some that might apply to our landlord clients.
Yeah, so there there was some guidance that came out from SBA indicating that the general SBA loan requirements that make certain businesses ineligible would still apply to PPP loans. There's some confusion on that point, and so we have this note at the bottom of the slide saying subject to change, because it's a little unclear whether that's actually the intent of the CARES Act and of the PPP to have these businesses be ineligible. But it seems like these categories, do apply, and that businesses are ineligible if they're ineligible under the general SBA loan regulations. We just put up a few categories here. There are others, so this is not extensive, but I think the one that comes up most often for multifamily folks is if it's a passive business owned by a developer or a landlord. And I think Mark, you're going to get into that in a little bit more detail.
I am. No, and let's talk a little bit about that for apartment owners. So, and let me explain why there's some confusion here. So when Congress passed the act, and as many of you know, this was a really rushed process, right? Everyone got together and said, oh my God, we need to do something. They threw it together. The Senate put together their proposal. The House made a few changes. There was the whole drama over whether it was going to be signed or whether it could be done by voice vote. So this was hastily put together. The act does not say anything about SBA eligibility. It simply says you have to have less than 500 employees, and it's going to be administered under the SBA guidance. So that is, there was a lot of hope, I think, around landlords saying, hey, we don't have to worry about the passive owner requirement because it's not in the bill. What happened is then, I believe it was Thursday night of last week, we got interim guidance from the SBA, and they said, yes, actually, we interpret it because there's references to the Section 7A loan program, that's the existing SBA loan program, that they believe that these requirements did apply to loans. And that's where we are right now, but it is interim guidance, meaning there has been no final guidance, and there has been a lot of lobbying going on at the SBA level on two issues. One is the affiliation issue we're going to dive into in a minute, and a lot of the VC folks are upset about this, but also a number of people are talking to folks in DC about this passive owner requirement and saying that shouldn't be part of the final guidance because it was not part of the bill. And not to jump to the takeaway message at the end, but we are telling folks, I would not let this necessarily stop you from applying because the final guidance may be different. You can get your application in and see what happens with the final guidance. So, but the question that many of you may be asking is, what does it mean to be a passive owner of the property? And there is guidance under the existing SBA program, the 7A program, that explains what passive ownership is. And as you would expect, it ties into some of the same definitions of passive ownership that apply under the tax provisions that the IRS interprets in terms of active participant in the role of business. So the question then becomes, if that's what it is passive ownership, someone that's not actively involved in managing the property, are there circumstances where you could be eligible for a PPP loan? And again, I think this is an area where we've gotten a lot of questions, and there are more questions than answers on this. I do think there may be circumstances where depending on the level of involvement and the relationship with the property manager, you may be able to argue that you don't meet that passive definition, and you would have employees that would be under 500 that would qualify for you. As we're going to talk about in a minute, one of the other big potential stumbling blocks for most passive owners is the payroll component, because the way you apply for this loan and the loan amount is determined by your payroll. It's 2.5 times your monthly payroll. So I think if you're a landlord, you're going to need to have payroll expenses that you can document and show as your calculation. If you don't have payroll, you're going to have real challenges. And we can talk, I'll talk a little more about that towards the end in terms of how you count it. I know many of you have asked, well, I don't pay the payroll directly. I have a property manager, but I'm reimbursing the property manager for those payroll expenses. And so can I apply for the loan, or can the property manager apply for the loan? And our view is that in almost all cases, it's going to be the property manager who actually employs the people and has that payroll expense that's going to be making the loan. There's nothing in the current guidance that suggests that if you are reimbursing someone else for payroll expenses, that you in fact directly have those payroll costs. And so the intent and guidance is all around the focus on who's actually paying the employees, because as we'll talk about in the forgiveness component, it is also tied into the forgiveness of keeping those people employed. So I will try. I've also gotten a question about joint employment. I'll try to deal with that in the Q&A session. But I think the bottom line is the fact that you as a landlord are reimbursing a property manager through your management fees, who's then in turn actually employing the folks, that property manager is going to be the proper person most of the time to apply for a loan. Now, we're going to continue to have the discussion around, are they eligible? And again, that's going to turn largely on how many employees they have. And it also may turn on how they are structured, which I think brings us then to the affiliation rules. And I may get you to chime in on this, Sarah. And let's actually, let's talk, this is talking about what those affiliation rules apply to. Can you remind everybody what the SBA affiliation rule is?
Yeah, so the easier answer is that there are certain express waivers, and that's what this slide is talking about, and who it might apply to. But the next slide is actually where we talk about what those affiliation rules are. And there are what I think of as three buckets of the affiliation rules, and how you determine whether a business is affiliated with another business. And the first one is based on ownership. So if an entity has more than 50% equity ownership of another entity, then those two entities are going to be considered affiliates.
Right.
That's kind of an easy, clear answer. There is also
and I'm going to jump ahead. We'll come back, but yeah, so we've got the list of the affiliations, right? So it's 50% ownership. I didn't mean to interrupt. I want to make sure people could see them on the slide.
Yeah, absolutely. Thanks, Mark. So as I said, 50% ownership, but then there's also a test that's a little bit harder and requires a little bit more digging to understand, is if a owner has the ability to prevent a quorum or block an action by the board or shareholders of a company, then that is also going to be deemed to be an affiliate. So it's basically, you can think about it as if somebody has control over the business, over the day-to-day operations, over the management of that business, then they are going to be deemed to be an affiliate. The second bucket talks about being based on management, which seems to overlap with what I just said, but it's a little bit different in that it's really talking about if your CEO or your president or some other officer that's in charge of the business also controls another business. That's going to be considered an affiliate. It would also arise if you had one person on your board of directors that really controlled everything, and they also controlled other businesses on other boards. So that ties all that in. And then the last big bucket is affiliation based on identity of interest. That's talking about your close relatives, your spouse, your parent, your child, siblings, those kind of relations. And if those folks have businesses that have similar or substantially identical business or economic interests, then those would also be considered affiliates.
Right.
And for all of these, any sort of contingent rights, stock options, convertible securities, agreements to merge, those are all treated as though they are current rights. And so you can't get around the affiliate rules based on owning through a stock option, for instance.
Gotcha. Thanks. No, that's great. I appreciate that, Sarah. And these affiliation rules have been around for a while. So the SBA, has these existing rules to try to determine if they're affiliated companies, in part to decide whether you are in fact a small business. But the question then has, a hotly contested topic, and one that guidance continues to come down on, is whether those rules that we just reviewed apply here. Because again, there's nothing in the act explicitly about affiliation rules. And so there's been some guidance here. And I don't know, Sarah, you want to highlight some of the waivers that we do know about, and then I can talk a little bit about the uncertainty around VC and PE companies.
Sure. Yeah. So the express waivers that are clear at this point based on guidance are, businesses that are in the accommodation and food service industry do not have to apply the affiliate rules. Franchises do not, and any sort of faith-based religious organizations are not subject to those affiliation rules based on religious connections. So in general, we think that most businesses will have to comply with the affiliation rules. There are different interpretations. Some folks think that just the 500 employees bucket stands alone, and that the affiliation rules only apply if you're trying to qualify under the small business concern prong. But I would say that's not a widely accepted thought process. So
right. So, and as I mentioned, particularly around the area of venture capital and private equity, this has created a lot of concern because there may be a whole family of companies, each of which is a small business, many in different industries, many impacted by COVID-19. But the current rules seem to say that if they're all share common ownership, in other words, a venture capital fund all owns a majority interest in them, that they have to be aggregated, and you have to look at whether there's 500 employees across all of those companies. I think they're very good arguments that was not congressional intent in trying to not provide aid to those companies, and those lobbyists are definitely working the SBA and are working on Capitol Hill to address it, either through legislation or through later guidance. So it is very much a stay tuned question as to how those are going to apply. But right now, it looks like that affiliation rule is going to apply.
And Mark, just to jump in there, there was a little bit of guidance that provided that if those VC or private equity backed companies, if the investors waive their rights under the organizational documents to control the votes, then that would be considered okay to make them no longer be affiliates. Obviously, if they're over 50%, they would still be, but if it's a minority interest and the issue is the control under the org docs, then we do have a little bit of guidance on getting around that. So
no, I think that's a good point. And again, for many of you landlords, right, you may have affiliates in terms of like a single purpose LLC that you've set up to own the land. That may not be much of an issue because typically there are not employees or very many employees in the single purpose LLCs, the real estate holding entities. The main role of the affiliation rule is aggregating employees over companies. So if you are a large company, but you set up subsidiaries in each state, for example, you might have a subsidiary in Virginia and a subsidiary in North Carolina, the affiliate rule is going to say you have to add up the employees over all your subsidiaries to see if you hit the 500 threshold. And that's problematic for some of the larger landlords. They have over 500 employees if you add all the employees in all the states. But if you looked at the individual LLC level, you would not. And so that's an example of where the affiliation rule might end up disqualifying. There's a lot around how do you count people and how do you stay under that 500 count? Because again, and just as a reminder to our beginning slide, that's the acid test that they're looking at is, are there more than 500 employees? If the answer is they're more than 500, you're generally out of luck unless you fit one of those other categories like restaurants or some of the other specific categories. So that's going to be the real impact of the affiliation rule. And again, we're looking at guidance. We're helping people try to figure out who to count. And we'll look at that question on the actual application here as we get towards the end of the presentation. I wanted to remind everybody a little bit about the terms of the loans. because there's been a lot of attention. The maximum amount's $10 million. That's real money for almost everybody on this call. And it's potentially forgivable, which we'll talk about. So there's real money that you may not have to pay back. That's why there's so much interest in the loan. I do have to stress though, because some people hear that 10 million and assume that's what they're going to apply for. You are going to apply, the loan amount is going to be calculated based on actual payroll costs. So it's 2.5 times the average monthly payroll cost in a 1-year period before the loan is made. So that's going to be for many people the actual calculation, and we'll talk a little bit about again how to calculate that amount. A couple other key terms I wanted you to be aware of. There's been some changing in the interest rate. The original legislation actually said up to 4% interest rate. Then there was discussion of it being only 0.5% interest rate. The guidance we now have from the SBA is that they're asking that the loans be at 1%, and that appears to be the ones that are being written right now appear to all be at that 1% rate. There was also some disagreement around maturity. The Act says that the maturity can be as long as 10 years. The SBA guidance now says the maturity should be 2 years with no prepayment fees. So those are the kind of the SBA standard terms that they're asking banks to issue is 1% interest, 2-year term, and then lastly, repayments deferred for the first 6 months. So you pay interest at that 1% rate, but you don't actually have to make any loan payments over the first 6 months. So pretty favorable terms if you qualify to get a 2-year loan of 1%, where for the first quarter of the loan period you're not even making payments. So you know, the idea is to get money into the economy, and these terms reflect that congressional desire. A few other points I wanted to cover. You know, some people say, hey, this is a great idea, I'm going to get several. You're limited to one. So you should apply for your full amount, apply for that maximum amount, either the 10 million or the 2.5 times payroll for it. And you do have to certify that you have not received and will not apply for another PPP loan. So it is a one-shot deal. They have given guidance saying you're allowed to amend your application if you discover new or different facts. So that may be an option, but don't be thinking you're going to, you know, apply half now and half later. You should do a one-shot deal for the maximum amount that you can get. Let's talk. I wanted to, you know, if you get the loan, everyone's asking, what can we use it for? Sarah, let you cover some of the ways that our folks can use the proceeds.
Yeah, so the Act provided that the proceeds can be used for several items. The most significant is those payroll costs. Can also be used for mortgage interest payments, rent or lease payments, utility payments, and interest payments on debt. All of those things must have been in existence as of February 15th, 2020. So if there, you know, are new utilities being set up, that's not gonna be an allowable use. But if they were in existence earlier this year, then you can use the proceeds to pay for those things. The guidance added a restriction that said 75% of the proceeds must be used for payroll related expenses. So that has changed the mindset of a lot of folks to say, you know, we really need to be focused on our payroll costs, which we'll get into in more detail next. But just keep in mind that even though that these other things are allowed uses, that it's not necessarily your full amount can be used for those things. So you want to really focus on using it for your payroll.
Gotcha. And what are those payroll costs? Let's dig into that.
Yeah, so payroll costs are everything that is listed here: salaries, hourly wages, commissions, any cash tips, and benefits like sick leave and vacation leave, medical leave, group health insurance, retirement benefits. All those things get all added up on an employee basis, and then you add all of your employees together to get your payroll costs. There are some express exclusions from the payroll cost calculation, particularly if you have any employees that make over 100,000 on an annualized basis. You need to cut out any cash compensation that's above that 100,000 level per employee. So if you have somebody that makes 120, you're going to cap that at 100. So the first 100 gets included, the 20 extra would get excluded. You also have to exclude employer federal income taxes and FICA. Any non-US employees are not allowed to be included. So you've got to take those folks out. And then, as Mark mentioned at the beginning, under that Family First Act, where the Congress added some qualified medical and sick leave for coronavirus related leave, that also has to be excluded from the payroll costs calculation.
Great. And then let's talk a little bit about, so that's the payroll costs. We touched on some of the allowable purposes, but let's talk about eligibility for forgiveness, because that's what we're going to be moving into next.
Yeah, absolutely. So the funds that are used for allowable purposes, as we talked about, the 75% for payroll costs, and you have an additional 25% that can be used for the mortgage or the rent, etc. They are all eligible for forgiveness once you have proper documentation of those expenses and provide that documentation to the lender. So you want to make sure that you're keeping really good records of how you're spending the proceeds of the loan. We're even recommending that it might make sense to have a separate bank account so that you can easily track that money going out. The SBA will require repayment of any amounts that are used for unauthorized purposes. And if they're used fraudulently, then there may be criminal charges even.
So, and I think the reminder again for landlords is this, as we're going to get into this forgiveness amount, it's all tied to payroll. So I know some people were, very interested. They wanted the loan. They can see the impact, but it is designed to the amount is tied to how much payroll you have, 2.5 times monthly. And as we'll talk about, the forgiveness is tied to payroll, to this, to an 8-week period. So in this slide where we're looking at, how do I get the free money? That's what people are most interested in. And you get forgiveness equal to the amount spent on an 8-week period after the origination date of the loan on qualified uses, but at least 75% of that has to be payroll. So the basic idea was you can apply for 2.5 months of payroll, and then we're going to forgive 2 months of payroll or 8 weeks of payroll after you get the loan. So if assuming you prove that you actually used it on payroll, and again, it doesn't all have to be on payroll, at least 75% has to be on payroll. I think for many employers, it may be 100% because it's a fairly straightforward transfer of, this is how much payroll we had to apply for the loan, and now we're going to get forgiveness. And that start date's very important. It's the actual origination date of the loan. So not the date you apply, but when the loan is actually created and funded, then you get an 8-week period. So if you apply today and your loan gets approved on Friday and you get the funds, then starting, from that point, you look at over the next 8 weeks, you have to track all expenses, all payroll expenses and any of those non-payroll expenses like rent and mortgage and utilities that are listed, come up with that total amount you spend over that 8-week period, and that's how much you're going to get forgiven. Very importantly, that forgiven amount is not taxable income. So this is a double gift. You're getting the money from the government. And again, if you've applied for 2.5 months of payroll and you get 2 months back, this may be most, and in some cases all, of the amount of the loan. So I know some of our clients are looking at essentially targeting 100% forgiveness because it's tied to the amount of payroll that they had before and after. So it's essentially the government coming in and covering your payroll expenses for 2 months, which is what the whole plan was, because you've probably been shut down for 2 months, and so your employees can't work. So they're saying you pay your employees and we will reimburse you. The forgiveness piece, obviously no one's applied for forgiveness yet because the date to start applying was Friday, and the very first loans are just being issued now. So if forgiveness is a ways out, I think we're going to expect more guidance on it, but I think keeping those records and submitting that expense is going to be key. That then gets submitted in to the lender, and then that loan amount may be forgiven. And again, it may end up being a substantial chunk of the, or all of the total loan. So I wanted to also talk a little bit about the forgiveness amounts, because remember, the purpose of this is to maintain employment. So if you get your loan and then lay off your employees, you're going to lose eligibility. And so there are two concerns that Congress had. One is laying people off. The other is cutting people's salary. So the forgiveness is actually reduced in those two cases. So for the FTEs, the way they determine whether you've reduced the number of full-time equivalents is they compare how many you had in the 8 weeks after loan origination. So that's going to be that forgiveness period, to the number of employees you had in one of two other periods, either the whole period, the period from February 15th to June 30th, 2019. So we're going back a year and looking at the same February to June period in 2019, a year ago. Or you can look at the period from January 1st to February 29th. And there was a lot of discussion about why it was designed that way. Some businesses are seasonal or new, and so they may not have good figures from a year ago in terms of what the payroll was. That's why they gave the January to February option. On the other hand, because of month-to-month variations, there was some concern that looking at only 2 months was not going to be sufficient. So they gave you the opportunity to go back to 2019. So you can pick which period is better. Obviously, you'll pick the period where you had the higher, the lower number, because you want to compare to make sure you're not showing a drop. So the number in that group that you had the lowest number, they're going to compare and see, do you have at least as many FTEs for the 8 weeks after you got the loan as you did in those periods. The other congressional concern was a reduction in salary. So if you reduce salary during the 8 week period after you get the loan by more than 25% during the most recent full quarter they were employed, that will result in a reduction in forgiveness. But it is only for those employees making under 100. So if you had someone making 200 and you cut them back to 175, it has no impact on reduction. It's only a reduction in the people that are making under 100 if you reduce it for that 8 week period. And again, the congressional motivation is they want to make sure you're keeping people employed for the 8 weeks after you get the loan, or even bringing them back if you've already let them go. We'll talk about that in a second. That's one motivation, and the other is that you're not cutting their pay. So if you cut it, you're going to get a reduction in the reimbursement amount. So, and then, I get asked, this came up with one of my clients very recently. They had already let some people go. So they were concerned about the FTE numbers. If you reduced the level in between February 15th and April 26th, in other words, in the last couple months due to COVID, you will not be penalized by that reduction as long as the levels are restored by June 30th. So you have time between now getting the loan and June 30th to bring those people back. And again, the expectation and hope is that you will use the loan program to pay those people and then get the forgiveness of the loan in that circumstance. Do we want to talk, and maybe Sarah, you want to touch a little bit on the process for obtaining forgiveness?
Yeah, absolutely. So as Mark said before, there may be additional guidance that comes out on this, including we're assuming there'll be some sort of application form for forgiveness that actually gets released. But for now, the guidance is that you have to request forgiveness from the lender. You're going to have to provide documentation that verifies your number of full-time equivalent employees and their pay rates, and any documents proving that you made payments of mortgage, lease, and utility obligations if you're using the proceeds for those purposes. You're going to have to certify that those documents that you're providing are true and accurate, and that you have used the loan proceeds for those allowable purposes, keeping employees most importantly, and then any eligible payments for those other items as well. And then once that the lender receives that application for forgiveness, they have 60 days to decide whether you get the full amount forgiven, you're going to be reduced because of the items that Mark mentioned, or if they need more information.
Yeah. But, in the scheme of things, 60 days is a fairly short period of time. So you do get, you'll know whether that loan is forgiven or not. I'll talk a little bit about, we've been asked some questions about, well, what happens if it doesn't get forgiven, or the math is different and I end up having the loan. And the bottom line is it just becomes an ongoing loan obligation with interest at 1% and a 2-year maturity with that deference. So it's not the end of the world, right? I mean, you've been given the money, you hope to get it all back, but even if you don't, then you're just going to pay it back over a 2-year period at 1% with no payments for 6 months. So it's not a bad deal. And that's why we are encouraging folks, go ahead and apply for the maximum amount. You don't have to limit yourself to forgiveness. There's no prepayment penalty. So if you apply and got $2 million loan and it turns out you only get $1.5 million forgiven, that $500,000 you can either pay back immediately without any penalty and without other than the 1% interest, or you can stretch it out over 2 years and repay it. And again, the interest rate's very reasonable and the initial payments are deferred. So there's really not much risk in getting as much as you can, given the favorable terms, even if it ends up that some is not forgiven in the end. So let's talk a little bit about the application process itself. And Sarah, you want to talk a little bit about it? I think I've mentioned already it's actually being administered through banks, and there have been a lot of headlines around banks and some being overwhelmed with applications. But just take us through the process a little bit for the actual loan application, Sarah.
Yeah, absolutely. And this slide just gives you a little preview of the next few slides and how we're going to walk through this application process. So I think we can move right on to the next one, which is the question of where do I apply? So as Mark mentioned, you're going to go to your lender. We're recommending that you work with your existing lenders for a couple reasons. One, you're going to have a better relationship with those folks than you do with somebody you don't know at all. And they'll be able to, help you more if there's a pre-existing relationship. There are also requirements that the lenders accept the know your customer type of documentation through this program. And so if you work with your existing lender, they may already have that information on hand, and it will limit the amount of running around you have to do to get everything that they need to apply. There are other lenders that can be added to the program. The SBA made it so that any federally insured depository institution or federally insured credit union, as well as the Farm Credit System institutions, are all immediately available to participate in the program, even if they were not already an existing 7A program lender. Those folks are trying to get up to speed very quickly, and some of them are, but as we have said a couple times now, this was instituted so quickly that the banks are really struggling to understand what the requirements on them are, to deal with the crush of applications that they've received. We have heard a lot from different folks that the banks are not accepting applications from customers that they don't already have a relationship with. We've heard some talk that even if you have an existing relationship with a bank, they have already accepted the maximum number of applications that they're going to, and so they've cut everything off. Call around, try to see if you can get another bank to help you if that's the case. We have heard from some folks that some of the smaller, more local banks are actually able to help more because they don't have quite the same massive level of applications that they're receiving, and they don't have the same limits that some of the bigger banks might have. So keep those more local banks and lenders in mind as you're trying to find somewhere to apply.
No, I think that's great advice. And I know people have been asking, when can I apply? And this past Friday, April 3rd, was the first date for small businesses and sole proprietorships. And there has been a flood of applications. You've probably seen news. There have been some projections that the 350 billion is going to run out or may already be applied for. But there's also been some congressional discussion about actually trying to increase that amount. I've seen headlines talking about another 250 billion being made available. So, and then on April 10th, independent contractors and self-employed folks can apply as well. It is first come, first serve. So it makes sense to get in the queue. If you haven't already, I think that's a good, that's a good idea to apply because there are going to be, certainly we're going to get to the point, I think, where the money's going to run out and not going to be available. So work hard to find banks. I know that all the processing fees are being paid for by the government, and these are fully backed by the government. So banks don't have much to lose. It's more an administrative burden that particularly the large banks are simply overwhelmed with thousands or tens of thousands of applications, and they just can't process them. I think that's really the challenge right now. Is there's so much money, so many people that are qualified, that it's really created a crunch in the system. So again, just as a reminder and a contrast to the disaster relief that we talked about at the top, you don't have to pay a loan fee. Or the 7A fees that might apply are waived. You don't have to put up collateral. And very importantly, you're not signing any personal guarantee. So this is really a good deal. It's low interest, no guarantee, quick effort to get money into people's hands. That's one of the reasons it's so very popular. So I thought in the time we have left, and I know we talked about an hour, it's clear to me we're going to go over it, and we have, I think, 97 questions so far. We probably won't be able to answer all of them, but I promise we'll dig into what we can. I thought it would be useful to folks on the call, Sarah, if you could just walk them through the actual application form and some of the things that they may be facing if they haven't done it yet. And I would stress it's not that complicated a form. It may, take your finance person an hour or two to complete. This is not some really onerous loan application, in part because there is no collateral, there are no guarantees. But let's walk them through what they need to do.
Yeah, absolutely. So as Mark said, it's really a 2-page application form. The text is small, but it's on 2 pages. And you'll note the website address where you can find it right on the slide. Just one tweak is there was a prior version of the form that was circulating for a few days before SBA updated it. So you want to make sure you have the most recent application form. The easiest way to tell if it's the most recent one is it's only going to require 1 signature line for an authorized representative of the applicant. The prior form had a signature line for a 20% owner as well. So that's an easy way to tell if you've got the right one. The other sort of tip is that a lot of lenders are using an online system to accept applications and may have tweaked the form to fit into their online system. So you want to make sure you get the form from your lender and are filling out, exactly what they need you to fill out, rather than just the generally available form from Treasury. There are a couple disclosure issues that we're going to go through. As we previously talked about, you're going to have to disclose your affiliates, and then there are certain certifications that we'll walk through as well. In addition to the application, you're going to have to provide your payroll documentation. So the spreadsheet of how you calculated your payroll costs for the prior period is going to have to be given to your bank. They're asking for tax documentation to verify the payroll and some other stuff. So you want to make sure you have all that gathered and ready to deliver to your lender. And then, as I previously mentioned, the know your customer KYC requirements are going to be, the bank is going to ask for that information. Sometimes it's a copy of a passport or driver's license, things like that. And then we've heard from some folks that lenders are asking for other things that are not required under the Act. So you want to be responsive to your lender and make sure you're getting them what they need so that they can process your application as quickly as possible and get you where you need to go.
Great. Well,
So
let's
then,
talk. Yeah, go ahead.
yeah, so then we'll get into, how you actually calculate the loan amount to request. The first part of the application is going to ask for, your business name and EIN number and contact information. But then the next box, the first really important box, is going to calculate the amount of your loan. And so it's going to ask for your average monthly payroll. And so you're going to figure that out by aggregating your payroll costs from either the last 12 months, so a trailing 12-month calculation, or for calendar year 2019. There was a lot of confusion about that, but the new guidance that just came out at the end of last week gave a clear answer that borrowers can use either or in determining that average payroll costs amount for either the trailing 12 months or 2019. And that's going to be limited to employees who have a principal place of residence in the United States. So you're excluding your foreign employees if you've got any. Then you're going to take out any compensation that was paid to any employee in excess of that $100,000 annual limit, as we previously mentioned. Once you take that out, you've got your aggregate payroll costs that are eligible here, and you're going to calculate your average monthly cost simply by dividing that by 12. And then that amount goes into that first box on the application form. Then there's a second box that has the multiplication of 2.5 by that average monthly payroll, which is the amount of the loan that you are eligible for, as Mark previously noted, that it's a maximum of 10 million, but it's for most folks going to be some amount less than that because it's 2.5 times your average monthly payroll. And then I don't think we've mentioned this, you can add the outstanding amount of any economic injury disaster loan that you might have received earlier this year. You can exclude the $10,000 advance that you may have gotten under that because that doesn't need to be repaid, but the portion of the loan that does need to be repaid can be wrapped into the PPP program here. So if that applies to you, you're going to add that there. And then that final box just gives the number of employees that you'll have to add, which you'll want to be under 500, as we previously mentioned.
Terrific. I think one of the areas where people have had questions are payments to independent contractors. And I know some people were wondering about, if I make a payment to a property manager, is that an independent contractor and can I treat that as payroll? I think the guidance that we're seeing suggests that that is not the independent contractors they're looking at, that this is the independent contractors can apply for loans. So if you have an independent contractor in a small business, that can count, and that 1099 payments that are de facto employee payments to some independent contractors, right, you still have control over their work, can also be aggregated as employees and may count in that employee count. But I haven't seen any guidance that says contractual payments like what we're typically seeing with property managers would be independent contractor payments that are going to count for a payroll obligation. The other question that I've seen before, and I think some of the questions that people have posted relate to joint employment or circumstances where perhaps payroll, there's a joint obligation for payroll. We have a little bit of guidance on that. There is guidance now saying that if you use a payroll company or a professional employer organization, a PEO, that those wages would count for payroll, and those employees would count for the count of 500, assuming they're in the U.S. So if you have a payroll company, you've got employees, but many states say that the EIN of the payroll company has to be included for tax purposes. So let's say you're using one of these big payroll processing companies. The fact that you're using it and you're a joint employer with them does not disqualify you from the loans. Those payments that you're making, even if the checks go through a payroll company, still count, and you would still be eligible. Now, whether that extends beyond a simple payroll company or PEO is a question. Again, I think the the guidance we're seeing does not suggest that simple contractual payments or paying somebody else who then uses that money for employees would qualify. But that's, that's the guidance we're getting. And like many of the areas, I think there's still a fair amount of uncertainty around that question. There's no explicit guidance on joint employers under this act. There was some guidance under the Families First Act, stating that it would include jointly employed employees for purposes of counting the 500 that would apply under the FFCRA, the Families First Act. The Department of Labor basically said, you count the employee regardless of whether it's maintained on your payroll or someone else. And I think for the 500 count, that's probably true here. In other words, they would count as 500 if it's a joint payroll. And if they count for the 500, I think there's a good argument they should count for the payroll amount of your application. But we don't have, we don't have clear guidance on that question from the SBA, and there's nothing specific around property management in any of the guidance they've issued so far. So and that kind of brings us to the affiliation piece. I don't know, Sarah, this is one of the questions I know our clients have been struggling a little bit with. You want to just take folks briefly through this part of the application?
Yeah, absolutely. So after you get the sort of amount down, the next section is shown here, where it's applicant ownership, and you have to list owners of 20% or more of the equity of the applicant. You'll remember that when we talked about the affiliate rules, I had said 50%. So there's a little bit of it's not exactly overlapping here. And you are going to have to disclose, anyone that owns more than 20% of the equity of the applicant. There's only space for 2 lines here, but you should attach a separate sheet if there are more folks that need to be listed there. And the key here is just disclosing everything. If you think there are affiliate issues, you can add a little note to say, this person does not have control, and therefore the employees of this entity have not been included in my count, or something like that. Each situation is a little bit different, so you've got to talk to your advisors, and we're happy to help walk through specifics, but you are going to have to add this disclosure. And then there's also a question, if we go to the next slide, Mark. That question 3 there talks about the affiliation issues. So not only are you going to have to disclose your 20% owners above, but then you're going to have to answer this question 3 to say, is there anybody that you own your subsidiaries or your affiliates, and you're going to have to attach an addendum that lists the business and describes the relationship. Right. So that's a great place for you to add any color that may be helpful to your lender to understand, how you're doing your calculations.
Right. And again, this is one of the places on the application where you're going to have a separate sheet explaining what the relationship is, and what the ownership is, and what their employee count is, and that other type of information. So I think that's one that, again, you may need to get help with if you're unclear, but that's going to be an important provision. Then you've got these specific questions here, 5 and 6, talking about, the 5 talks about the 20% or more, and whether they are subject to any criminal charges. So that's what these address, and 6 addresses in the last 5 years whether any owner or the applicant has been convicted of a felony. Anything else we need to say on these, Sarah, before we move on?
Yeah, the only other one I was going to highlight is 7 there. It was an updated question from the original application form. So this one's a little bit more straightforward, I think, for folks to understand, but it's where you're going to confirm that anybody that you included in your payroll calculation has a residence in the U.S. So the answer to that should be yes there.
Yeah, and we've been getting questions too about people that have either foreign parents or sister companies in other countries. That's a complicated area that we don't have time to get into in depth here, other than I would say that's when you probably do want to get legal help on figuring out. I think 7 is clear that you're only counting the ones in the US. The question is if there's more than 500 elsewhere, does that limit your ability to apply? And I think the short answer is we don't know, but there are ways to try to color that. So, and then Sarah, you want to just tell them about the certifications in connection with their signature?
Yeah, absolutely. So there's 2 sections of certifications. This is the first one. Here you can read all of them, and you should read all of them as you submit your application. But you, as the applicant, are determining whether you are eligible to receive a loan. The SBA has given guidance to the banks that they can rely on an applicant's statement that they are eligible. So that's one thing to think about. You're also certifying that you're going to use the proceeds for the eligible purposes that we discussed. And then if you see, it's the 3rd bullet from the bottom there where it says, to the extent feasible, I will purchase only American-made equipment and products. So this was not in the Act, and really there's been no guidance on it except for it showing up in these certifications. So just something to keep in mind as you're thinking about operating your business going forward.
Yeah, it's amazing what they sneak in. They sneak in because somebody says, well, let's make sure they're going to take American money, that they're using it for American stuff. So I will see. I do. I think it's again, a product of things moving quickly that people are like, oh, and they get to the very end and they're like, I didn't know that was the case. Again, I think you have wiggle room with the extent feasible, right? If you've got a long-term contract for some equipment or some supply, that's non-US, it seems to me it would not be feasible to switch over immediately, but it's an interesting requirement.
Yep, absolutely. And then the second part of the certifications, it picks up a lot of the things that we've already talked about. You have to certify an initial that you were in operation on February 15th, that you had employees. You have to certify that second one there, that current economic uncertainty makes the loan request necessary to support ongoing operations. We've had a few questions come up on this. In terms of people, not necessarily having direct impacts of coronavirus issues. Maybe they're not fully shut down. Maybe they, have enough money in the bank to last them for a while, and so they're, not quite sure if they really need this. So just think about that one, and the language is very specific to say uncertainty makes the loan request necessary. If you don't have to show a direct impact or a reduction in revenues or anything like that under this program. You just have to, be using the funds for keeping your employees on the payroll.
Great. All right. Let's give a few takeaways and then we'll try to move to questions. I know we're already over our hour, but we've got over 100 questions, but I'm happy to answer those that we can now and try to do a follow-up. I do think, again, one of the questions that many people are asking is, when do I get the money? And unfortunately, we don't know. Some people have been told that their applications that they filed on Friday have already been processed and are expecting to get money as early as this week. Other people are being told that there's a backlog and it could be 3 or 4 weeks. I don't know, Sarah, what you're the latest you've been hearing from the folks you've been working with, or what advice we can give in terms of processing time.
Yeah, we've heard everything, to be honest. I was on a call yesterday and was told that billions have already been funded to people. So I'm not sure that that's true, but you know, depending on the relationship with the lender and how quickly they're able to process it, SBA is releasing, approving applications, and the banks are releasing some funds depending on, where things stand in the process. But we've also heard that it may be another month before some banks are able to release funds. So it unfortunately is not clear. The
second bullet point upon moving quickly is something we've definitely been stressing to everybody. You know, it feels early. It's only been, this is what, the third business day that you can apply, I think, or maybe the fourth, but it's early on, but I still urge you to get it in. It's a 2-page application. I think getting it in and getting it in now makes sense given the first come, first serve basis. There are already thousands of applications in front of you. And so trying to find a bank that will work with you and accept it is important. I know I got one of the questions that we received was noting that Bank of America has announced that they will only let people with existing loans apply. That is my understanding. There are questions about whether they can do that. The program is voluntary. Banks are not required to issue PPP loans, and there's not really guidance around how they choose. I know some people are upset about that. In fact, I think a class action was filed on Friday against the bank, but who knows how that's going to turn out or what the requirements are. And I know other banks are overloaded. I believe Wells Fargo announced that they were not taking any more applications, at least right now, because they're swamped. So I think finding the bank that will work with you, whether it's that local community bank or credit union or somebody else that may be less overwhelmed and has time to process it, is really an important recommendation here. And I think on Apple, you know, a lot of you have been asking, can I apply? I hope we've answered some of those. I'll try to answer more. I do think our advice is, if in doubt, apply and apply honestly. So disclose all the facts. If you think you've got more employees or you think you're counting something that is your, you know, a joint employment relationship, I think you can apply and be very clear and candid about how those numbers were generated. And that way you're in. The reason to do that is the guidance may come down that says, yes, that's fine. And then you'll be in the queue, as opposed to waiting until guidance comes out in a week or two and the money potentially being gone, or at least being long delayed. So I think that's important, because guidance is coming out. We don't have final guidance. We've been getting new kind of FAQ guidance almost every day. So things are happening quickly, and lenders have a lot of discretion. Sarah, any other final points from this slide, or other things that you want to share with our listeners?
Yeah, I think you covered it, Mark. I think, you know, our big takeaway for folks is to, you know, do what you can, apply, try to understand everything and disclose everything, and really work with your lenders to get where you need to be.
Great. So thank you for participating. I did want to put on the screen some of the folks that do multifamily work. I do a lot of work with the multifamily clients in North Carolina. I'm in our Charlotte office, but these are folks in our DC and California offices that also do a lot with multifamily. We certainly appreciate the NAA inviting us to do this webinar. I know we've gone for a while, and I know we've got 100 questions. I'm game to stay on and try to answer some of those if you want to stay on. If you can't, I understand we may try to circulate an FAQ later. I also understand that we may unmute the mics and let people ask questions. So I'm going to turn it back over to Scott to see how he wants to handle wrap up, but I'm happy to stay on and answer some of the questions in this long queue.
Mark, I would say we can do this however you would like. Like you said, there are about 130 questions in the Q&A, I believe. If you want to run through some of those quickly to see if there are some in there that you haven't already addressed, you can do that. And then, like you said, though, we're logging those questions, so we can also go through those after the webinar and work with you guys on a FAQ that we can get out to the membership as well.
Great. Thanks, Scott. I'll go through some of those, and I apologize if some I can't answer. I think the first one I see is, can landlords with a LLC use net earnings under IRS 1065 as payroll costs? I'm not a tax expert, although I think the answer is going to be no. The focus is on actual payroll expenses, so earnings are generally not going to be the same as that 2.5 months of payroll expense. So generally that's going to be a no. I answered the question about Bank of America. I think they are. That is my understanding of their policy. The third question was, is it clear that privately owned rental properties are eligible for the PPP? And I think the answer is yes, if you meet the other requirements. The fact that you operate rental properties is not a disqualifying business, subject to what I talked about with the passive issue. But if you're actively managing properties and you have payroll, you've got properties and you've got someone on your payroll that's doing the leasing or the maintenance or other stuff, I think those payroll expenses would make you eligible. So if you meet the small business requirement, I think that you would be eligible here. The next question asks about funds for employees commuting to work and public transportation. I've not seen any guidance on that as an employee expense. I don't know if Sarah, that's a new one on me. Have you dealt with commuting expenses at all, or are you aware of any guidance there?
I'm not aware of any guidance. I would say that if it was an existing benefit that you were paying for commuter costs for your employees, that it may be wrapped up. But if it's something new that you're planning on instituting, I don't think that would be covered.
The next was a formula for full-time equivalent. It's my understanding they're using the DOL, Department of Labor FTE calculations, which I believe are based on a 40-hour work week. So if someone's working 40 hours, they are a full-time person. If you have two people working 20 hours, then you would have 2 1/2 FTEs, and they would total up to a full-time equivalent. And similarly, if you had 4 people working, 10 hours each, that would tally up. There is some nuances around that with some shared work time and stuff. So you could either check the Department of Labor regulations or to consult with an attorney if you've got a very unusual circumstance. But typically, they would look at part-time, you'd add up part-time workers based on how many hours over 40 they would work to come up with an FTE calculation. The next one is, again, I think I've addressed it, but I know many of you had similar questions. So if you use a large third-party property manager, can you treat them as a PEO and submit as an owner? And basically the answer, I think, is almost always going to be no. Right? Because you've got, assuming you have a contract with that property manager and are paying them a management fee that is then being used to pay the individuals, that property manager would be the right person to submit the payroll. You as the owner really don't have that. And I think that the PEOs are where you're funding a payroll account, and those go out typically as joint checks. So you've got this, one of these big payroll companies doing it. I think property managers are different in my mind than PEOs. So I think you would have concerns. The second part is, what about employment claims? I do think that's going to be an issue because you're going to be submitting a federal, if you decided to try to do it, you're essentially representing to the government that these are all your employees. And again, I think that's a dangerous position to take if they're not, both in terms of workers' comp and liability for workers' comp insurance, as well as possible employment claims brought against you. I don't think it's designed that way. I think it's designed for the people that carry them on payroll. And in a typical case, that would be the property manager who would be submitting the payroll application. So I know I've addressed that a couple times, and that's a question we got even before the webinar. A lot of people have that concern. The next one was, if we let go an employee at the start of COVID, can we rehire and get forgiveness in full? I think I did answer that, and the answer is yes, if you bring them back by June 30th. And the next one is, I own as an individual, not a corporate entity. Does it apply? Potentially, individual business owners, sole proprietorships can apply. The biggest question is going to be, do you have payroll? In other words, you need to have payroll expenses, somebody that you've hired and are paying. If you have payroll expenses, you may be able to apply. Not all owners do, but the fact that you're set up as a sole proprietorship is not in itself a bar. You do have to wait until, I believe, the 10th to submit an application if you're an independent contractor or sole proprietorship. The next question is, how long do you have to spend the funds? So the 8-week period is what they'll look at for forgiveness, but there is no timeline, and Sarah can chime in if I'm misremembering this. I don't think there's a deadline to spend the funds. There's only, if you want it forgiven, you have to spend it in that 8-week period. But if you got the money and didn't need it right away and spent it in 6 months, I think it's fine. You can spend it whenever you want. Obviously, most people want to spend in that first 8-week period to get the forgiveness aspect, but it's not a deadline. If you haven't spent it, you can wait.
Yeah, that's right, Mark.
Right. Let's see. Third-party management that's employer. Yeah, I think I've answered that several times. I think the management company typically is the employer, and they're the ones. The next one asked about HUD loans. I don't think the presence of HUD loans is a disqualifying factor. I haven't seen anything on that unless you have, Sarah. I think you can have Go ahead.
I don't think it's disqualifying. The one thing I would say is, for HUD loans and any other loans that you have, that are currently outstanding, you want to make sure that the terms of those loans don't prohibit you from getting this additional loan. And you want to make sure that you get any consents or anything that you would need under those existing loan documents.
Great. Can you apply at the property level? Needs to be the small business that applies. So the answer on that depends a little bit on where you are. Obviously, if you've got affiliated companies, any of them can potentially apply that have payroll, and then they would disclose the other affiliations. The next one is, if you use a payroll company, how do you prove the expense? I do think you could use the payroll records of that payroll company are what you would submit. I don't know if you want to give guidance, Sarah. I know that's the payroll company question is one we have some guidance on, but I do believe you can take the payroll records of that company would be the way you would calculate the 2.5 months and submit it.
Yep, exactly. The guidance says that they consider acceptable any payroll documentation provided by that payroll provider.
Right. So the next question from Deborah is a good one about, you've got several different properties and how do you apply funds to the property? So that is, if you are the manager and are paying people through a PEO and you've got those employees and they manage a number of different properties, I think you're the one that would apply for the reasons I've talked about. I think the way you distribute those funds back to the properties is going to be governed by your individual management agreement and those accounts in terms of billing. So that one is going to depend a little bit on your contractual relationship with the property owners. I can't give you a lot of details there. You'd have to look at that at those contracts to try to understand. Let's see. So Linda's question is, are you prevented from applying from other loans? So you can't get the tax credit that I talked about at the beginning if you apply for a PPP loan. I'm trying to remember, Sarah, if there are other disqualifiers. And obviously you can only apply for one PPP loan.
Yep.
That's the one I know about in terms of disqualification.
Yep.
Let's see. The next one is, given that it's based on 7A and the ineligible business, right? So I talked about this during the presentation in terms of what is passive. I think that's true. Right now they're using that guidance to say passive can't apply. That guidance may get changed. And again, it's worth looking and thinking about whether you can qualify as an active owner of the business as opposed to passive. Let's see, this is the $10,000 grant. I think that's for the disaster loan. I don't know, that's the other question from Linda. I don't know if you want to address that at all, Sarah. I think that's the $10,000 grant portion of that disaster loan. I think qualifying small business, my recollection is, and again, we touched on that at the very beginning of the program, if you are qualifying small business and can show that direct COVID impact, I think you qualify for that disaster relief, but I don't have that grant application in front of me. So I think that's, I do think that's a separate application. It's not part of this PPP process. But you can apply for both. You just have to indicate that you received a disaster loan when you apply for the PPP to answer that next question. Let's see. I think this also talks about the using the property manager issues and who to apply. So I think I've covered that question. The specific question about the EIDL, I don't know the answer to that specific one here. I'd have to go back and look at that because we've been focused right now on the PPE. The EIDL was implemented a little earlier, so I'm sorry, I don't know the answer to that. On 501c6s, I know we've talked a little bit about that, Sarah. It's clear that 501c3s are eligible, but I'm not sure, and it's clear religious institutions are eligible. Do we know about 501c6s, or is that an area there's still uncertainty?
I think there's still uncertainty there. The Act itself specifies the 501c3 as the nonprofit organization. So I think it's still an open question whether that was the intent to actually limit it fully to the 501c3s, or if other C numbers are actually included as well.
Okay. There's a question about the suspended construction projects. I don't think I've seen any funds earmarked to that, but that's certainly an issue a lot of our landlord clients are concerned about. Construction in some states is completely stopped, in others it's deemed an essential activity. And going forward, I've worked with a number of construction clients on that, and there are some ways you can potentially do some construction activities with social distancing. But to the specific question on money, I'm not aware of any financial money tied explicitly to suspended construction. Again, we've got a number of these about property management companies, so I think we've covered that in some depth. Let's see. And eligibility we talked about. I talked about the leave and the returning employees, so I think we've covered the question there. I'm sorry, I've reviewed the first dozen or so, but we're into ones I had not pre-reviewed. But I'm happy to, for those of you still on, I'm happy to have you to listen again or check on our follow-up FAQs. Some of these are very specific to your individual circumstance, and I would have to say you can ask those offline or send an email to us, and we can try to deal with very specific questions in terms of timing and individual circumstances. And the slides will be, I wanted to remind those of you still on, as I said at the beginning, the whole presentation's been recorded and the slides will be available. We'll send you a link when that is ready to go. There's a question about the total sales cap. So our understanding is right now there is no revenue or sales function. If you have under 500, you don't have to worry about total revenue or sales, even on the affiliation. So the affiliation rule is going to matter for the 500 count, but we don't believe it's going to matter in terms of total sales. Let's see. I think we've talked about again, there's no SBA loans explicitly for loss of rent other than the various loans we've been talking about here and the economic disaster aspect. All right. There is a question from Sam about the CARES Act versus the tax credits, and I think I've addressed that, but so just to be clear, you cannot claim the tax credit if you get a PPP loan. So those two are mutually exclusive. The other thing that people sometimes get confused about is the paid leave that they may be getting under the Families First Act. That cannot be counted as part of your cost here. But the tax credits are mutually exclusive with the PPP loan. You can choose one or the other, but you cannot get both. Let's see. So a good question here on affiliates. Go ahead. If each affiliate has their own payroll and they're in the US, they can each apply. They would just be disclosing the other affiliates. In other words, it's not, you can have different affiliates each apply. They just have to disclose the affiliate relationship and count those employees for purposes of accumulation. Go ahead, Scott.
No, I didn't have anything to add, sorry.
Okay, sorry, I thought someone else. And did people have any verbal questions? I don't know if they're unmuted. I could try to answer others. I think I've, let me just see if there's any other general questions. Sorry, several people. I think I've tried to answer. Several of them are the same question.
Yeah, I think Mark, we could probably take some verbal questions now if you want.
Great, let's do that.
Is there anybody that has a question that's still on that has a question that they would like to put to the group?
Hello, can you hear me? My name is Netta.
Yes, Netta, I can hear you.
Yes, so many of us who have rental properties don't really have a formal business that we operate under, although I do have like a DBA. It doesn't have a business license. Maybe it's my Social Security, I'm not for sure. but all of my rental expenses are identified on a Schedule E. So on the Schedule E, of course, you show the rents that you receive, and you show all of the operating expenses. And I have ongoing construction that's being done at one of the properties, and those costs are reflected in the repair section and in the maintenance section of that Schedule E. In order to keep the contractors going, you know, I need the money from the PPP loan in order to continue, because I do have tenants that are leaving because of COVID-19. Can I use my Schedule E as a form of applying for the PPP loan?
My answer would be probably not, because the fact that you're a sole proprietor and haven't set up a company is not necessarily a problem. Sole proprietors can apply, but you have to have actual folks on payroll. So unless you are directly paying those construction workers as your employees, you would not have, you're probably not going to have any payroll expense. And the loan amount's determined by your payroll over the last 12 months, the average payroll over the last 12 months. So it's not going to cover future work. You'd have to show that you had people working for you over the last year and then calculate 2.5 months of average payroll expense.
So I would be able to do that using the Schedule E lines under repairs, because that's where they are paid, and they have been working for me over the last 12 months. And based on I guess it's the federal government's definition of an employee, which is that you yourself supply them with the tools and you yourself buy the materials to hand to them. Employee.
So are you withholding federal payroll taxes from them, the Social Security and Medicaid taxes? Because I think that's when they look at your payroll expenses, they're going to be looking at your employees and what you've been paying in terms of payroll taxes on those employees, which again, I don't know how it's structured. If you have hired them and they're your employees and you have that payroll expense, I think that would be appropriate, but I would just caution you that it needs to be a payroll expense as opposed to some other type of treatment. So if you are showing them as your employees and you've been giving them W-2s, you know, with the payroll showing taxes withheld, and you've been paying the employer portion of those taxes, I certainly think you could include those. But if you've been paying them on some different basis, I think it may be very challenging to do it. And again, it's probably something that you may want to talk to an individual lawyer about and let them look at the actual records of that. I don't work with too many sole proprietors, so it's not an area that that I've got a lot of experience in to give you explicit advice. But I think that would be the question: is you know, are those really payroll expenses? And that's probably something you need. You know, I'd talk to somebody specifically about. So it's a good question.
I have a question.
Go ahead.
My name is Mo. Can you hear me?
Yeah, I think I've got two people, but yes, go ahead. Go ahead.
Mo.
Mo.
I'm a realtor, and I have a S corporation, and my commissions, when they come in at the end of the year, I get from my broker a list of what commissions I've made, and I pass them to my S corporation. And I also give myself a salary to W on that corporation. Would I qualify for PPP for 2.5 times
super duper tight.
2.5 times of the W2 expenses that I have for myself as a 1% S corporation?
That person, Chris said that was a little bit too tight.
That's a good question. Sarah, are you still with us? Any thoughts on that? So you've got a 1-person S corporation with a single employee.
I think an S corp with 1 employee would be eligible to apply for the payroll cost. 2.5 times the payroll cost for that 1 employee.
Mm-hmm. I think so too. I mean, I think that's one where if you're structured that way and you've got your, even if you're the only employee, the way I read the rules, nothing prohibits you from applying for that based on your history of compensation, to apply for 2.5 months of compensation looking back over the past year, if you're the employee and you've been paying yourself as the employee. So yeah, I would think you could apply. I think I heard another person with a question as well.
Hi, I'm curious as to if we're a larger property manager, we have about 600 employees, 625 employees, and I was looking at your exceptions, and all your employees are at different locations, let's say about 75 locations. I looked at the NAICS standards or the code, and there doesn't seem to be an exception for the residential property manager code. Is there any way of looking at that? I've heard anecdotally that some are still applying, but I can't see any exception. And I'm just wondering, is there something I'm missing?
I don't think there's an exception that you're missing. I mean, I think if you got the over 500, the fact that they're over multiple locations only matters for restaurants and those other codes. It's not going to cover your code. So if you've got over 500 employees, you probably are going to have to just look at the other relief, that first slide. You are going to be eligible for the tax credit, and you may be eligible for some of the larger business relief that's coming down the road. But I don't think there is no exception for property management if you're over 600 under the current guidance. I think you may well be out of luck.
Perfect. Thank you.
Mm-hmm.
Hello, this is Greg. I have a question.
Go ahead, Greg.
Yeah, I've got a PEO situation, but we're not reimbursed by our clients. The payroll directly hits their property and doesn't hit our books. So we don't pay the employees out of our bank accounts. Doesn't show on our financials. It shows directly on theirs. Would that be a situation where they would be able to apply for the loan? I know that when we were talking to this lender and they asked us our revenue, and certainly our revenue number doesn't include numbers that would allow us to show that level of revenue that would even cover.
That's a good question. I mean, because I think the guidance that we have on PEOs is that the actual payer, if you're using a PEO, the business that uses the PEO can apply. And I think the understanding is you would use the records from the PEO to show that. In other words, but I'm not, it sounds like that's a little different than your situation. How do you pay the PEO and then they pay the employees? Is that how it works?
No, the PEO has a direct ACH contact with each one of our operating accounts or trust accounts on behalf of the property.
Okay.
And so they pull the payroll, each payroll period, directly out of the property operating account. And so we've got detailed records for each property showing that transaction. And again, it never hits our books. We don't see it in our.
Right. I mean, that might be an interesting, again, this is an area where there's not a lot of guidance, but I think there's an argument there that if those individual properties are using the individual properties are using the PEO to pay. And so those individual properties in that circumstance may be the right people to apply, right? If the money never goes into the management company, do they have a contract with the PEO, or is the contract between you and the PEO? I guess it's an interesting structure.
Yeah, the contract's between us and the PEO. But again, the challenge is we wouldn't, in our tax ID number, we don't show that level of revenue to support that payroll. And then it would, I guess, then go into the passive question on the properties, whether they would be able to apply or not.
Right. That's right. They may qualify under the under 500 employees for their individual property using a PEO, but then you're going to have the passive issue.
Correct.
So that is kind of a double. That's a challenge there. And obviously, this is new territory for a lot of us, right? No one, when we were structuring these agreements, envisioned kind of the federal government coming in and trying to pay payroll. So I think that is part of the challenge. And yeah, that's a scenario I have not dug into, but it sounds interesting there. And again, that may be one worth exploring a little more directly, either with an attorney or submitting an application explaining it and trying to get clarification around it.
All right, thank you.
Yep.
I have a question. Can you hear me?
I can hear you. Go ahead.
Our Fannie Mae loan says the borrower is not allowed to seek external debt financing. Well, I don't view this as debt financing, but my processor said we may not be able to apply for this. So that's my first question.
That's a good one. And welcome Sarah's thoughts. I know we have told people to make sure to check with their loan covenants to make sure that they're not going to, be in violation by applying for the loan. Obviously, particularly if your anticipation is it's all going to be forgiven, I would think most borrowers would be happy to let you get money at low interest with a forgiven. But I can't. You'd have to look at the individual covenant or have a discussion with that bank to make sure, because I don't. It's going to be governed by the individual covenant language in your loan.
So then like Hunt Mortgage is the processor, so we'd have to talk to them or Fannie or.
Do you know, Sarah, whether there's been any guidance from Fannie around this? I haven't seen any.
I haven't seen any, but that doesn't mean it doesn't exist. I haven't been focused on that.
I might check with both of them. I might try to look to and see. It's possible, again, this is moving so quickly. It's possible Fannie has given some guidance on loan covenants and whether or not this, would trigger those. So it might be something to look at. I have not checked that area specifically. So I might check there by going to their website or looking for that. But then again, your individual mortgage holder might do it too. My guess, even if you need a waiver, I would hope that you could get it. Obviously getting through and talking to humans can be a challenge at this time with anybody there. The other issue to just think about, and certainly you want to be careful around loan covenants, but you'd have to decide too what the practical implication is if you do it and it gets forgiven. It just may be worth analyzing that. You don't want to be in a default situation where it triggers other defaults. So I'm not encouraging you to violate it, but I would look at the consequences and try to get in touch with somebody. Because I think, again, most borrowers, you're going to be more secure if you're able to get this forgivable loan than you would otherwise. So common sense says that borrowers should not object to a PPP loan, particularly if it's going to be forgiven, because it improves your creditworthiness, not, as opposed to making it worse.
Yeah, exactly. And so this may be a really stupid question, but I saw towards the end of the slides where there's questions about the businesses of owners, quote unquote. Our owner is an LLC and none of the members own 20% or more, but all of them pretty much have unrelated businesses. Do I have to say anything?
I think you only disclose people with a 20% more or more ownership. So if you've got owners that hold less, I don't believe they're disclosed on the form.
Okay, cool.
Great.
Thank you very much for your help.
Of course.
I have a question.
Yes, go ahead.
Yes, you and Sarah were explaining earlier how you calculate the amount of the loan that you ask for, and it was based on your 40-hour-a-week employees, your full-time employees. Well, in our company and in our industry, quite a few of our full-time employees actually work 37.5 hours a week. How does that factor in?
So that's a great question, and I think I may not have been clear. There's two parts to it. For the loan application, it doesn't matter whether they're full-time, part-time, or how many hours. You actually look at your actual payroll records for the last 12 months and come up with your average monthly payroll, multiply that times 2.5, and that's your loan amount. So it doesn't matter for the loan amount whether they're working 37.5 hours or 20 hours or 10 hours. You're just going to look at your actual average monthly payroll and multiply it by 2.5. The FTEs come in terms of the layoffs, where they are looking at whether your total number of FTEs has changed. So that would be if you've got less employees now than you had remember there's two different calculation periods, that's where they would look at FTEs. Again, I think if you're consistent with you may be counting your 37.5 hour as an FTE, but if you also have 20-hour employees, part-time employees, then you do have to do a normalization to the 40-hour work week for those other FTEs, I believe. And again, I haven't looked at those DOL regulations recently, but that would be something to just look at in terms of calculating the change. If you've got the same number of the 37.5, it's not going to matter. But if you let 137.5 go and brought in 220s, I do think that may change. That, yeah, I think you've actually increased your FTE under the Department of Labor calculation.
Okay.
And additional guidance may come out on the forgiveness side. We're expecting it to come out, so that may be further addressed too.
Yeah, that's a great point, Sarah. We're just assuming that it's kind of calculated that way from other federal laws, but we don't know exactly how the SBA is going to look at it. Or in this case, it's the lender. The lender actually, you submit your forgiveness application, which includes information on number of full-time employees, and they review it and decide whether it's eligible for forgiveness. So it's somewhat uncharted territory. So it's a good reminder, Sarah, that we don't know. They may, and not clear how they'll calculate it, but that's the guidance we've gotten as you kind of compare total number of FTE equivalents.
Thank you.
Yep.
Hi, everybody. This is Justin. Can you hear me?
I can hear you, Justin.
Hey, thank you all so much for putting this on. This is definitely valuable information. I do have a couple questions in regards to once we have applied, usually what is probably the estimated guess time of finding out if it's been approved or not?
So we've been hearing a lot of different things. I know some people that applied Friday found out Monday and Tuesday that they were approved. So that's happy news. I think other people have been told that they're backlogged and it may be a matter of weeks before they learn whether they're approved. I don't know if you want to add any color to that, Sarah, but I've been hearing a pretty wide range.
Yeah, same here. I would say, the relationship with your lender really matters in terms of how quickly you can get them to process your loan. That it's supposed to be first come, first serve, but anecdotally that's, we're hearing examples of banks, treating customers differently. So, the better relationship you have with your bank, the sooner they are likely to be able to get your application processed.
And the good news is we bank with a smaller bank like y'all had recommended earlier. And there was definitely a little bit of a backlog. We were informed yesterday that everything has been submitted. So hopefully that'll be something quick. Another question I have is, does a company need to use their reserves, or are they able to use the PP money first for the payroll, or do they need to use the reserve money for payroll, or does it matter?
I believe that doesn't matter. I'll let Sarah correct me, but we haven't seen any guidance suggesting a requirement to use other monies first. I think you can use that loan money immediately for payroll if you want to.
Yep, I think that's exactly right. And I think the intent of the law is that you are using that loan money, in those first 8 weeks after you receive it. So yeah, I totally agree, Mark.
Right. And that'd be our recommendation, right? Use that, get the money, use it for payroll, and then you've got a nice package to then immediately submit your forgiveness request to say, I've used up this money for payroll and these other permitted expenses. And then 2 months later, turn around and submit a forgiveness request right back in to say thanks and now forgive the loan.
And as soon as we can submit the forgivenesses after the 8 weeks, correct?
I believe that's right.
Okay. Thank y'all so much.
Yep.
Hi, this is Barry. Can you hear me?
Yes, Barry, go ahead.
Hi. So two things for the gentleman that just was asking. Our application was actually submitted on Monday. We have a small bank that we worked with for a long time. We were approved Tuesday. So it was a very quick thing.
Congratulations. That's great. That's good news. That's good. That's the way it's supposed to work, but we haven't always heard that.
I wasn't expecting it. For the record, this bank actually was working on it Sunday night. I got a call from my banker at 10:30 asking a question about a document. So They were really on it. So it really is about the bank and the relationship. But with that said, we have 200 employees. We are the direct employer. Our client reimburses for the cost of the on-site employees. What we want to do is to extend the benefit to our clients that are reimbursing us for the cost of the on-site employees. Is there any stipulation that says we can't do that if that's an agreement we have between us and our clients, knowing, of course, that we're on the hook for it? Therefore, we have to have a relationship we know the client would.
Yeah, no, I'm not aware of any restriction that would prevent you from doing that. Essentially giving them a credit back for the, since you've gotten the money to cover those employee costs, giving a credit back to the clients makes sense to me, and I don't think there's any restriction on that.
Great. Thank you very much, and thanks for your time.
Joe, you're welcome. No, thanks for participating. Appreciate the question and the good information about at least one happy story. So
Hello,
if you want to share the name of the bank, people may be desperate for thoughtful bankers. You're welcome to. It's not a promotion opportunity, but I've had a lot of people saying, give me a small bank that can act quickly. And
I would say that I don't know whether they're working only with people they've had accounts. We don't have loans with them. It's a small bank in Washington called Washington Trust. They're fantastic.
Right. No, I like to hear that. That's a great story. And I know a lot of bank folks are working really hard to try to get these processed quickly, and they know how important it is to get the money out just as fast as they can.
Mm-hmm. Yes, hi.
This is Greg. Can you hear me?
Yes, I hear you, Greg, and I heard someone right before you. I'll get to you next if I can, but go ahead, Greg.
Yes. Okay.
Hi, thank you. I'm one of the lucky Wells Fargo customers who basically was told to find another lender due to the volume of requests. 3 decades down the drain. What can you say? I'm curious, how many lenders should we apply in order to increase our chances? I'm a little nervous about just letting it sit out there with one lender with whom I've never worked. I'm wondering if maybe 1 or 2 or maybe even 3 applications is appropriate.
I don't think you can. Again, I invite Sarah to pull in, but as you may recall, the application asks if you've applied for another loan, and our understanding is if you check that box yes, your loan will be disqualified. So I don't think you can apply multiple. I think it's a one-shot deal, and if they determine you've made another application, they'll cancel your application. So I think you do want to try to find the right bank, but I don't think you can do multiples. Sarah, any thoughts?
Yeah, so the certification on the application says you have not and will not receive another loan under the Paycheck Protection Program. So I do think you probably could apply with multiple banks. You just want to be careful that, they're not processing it and getting you money that would be duplicated. But I do think you could apply at more than one place at a time. Obviously, it's a matter of bandwidth in terms of how many times you want to be filling out the same application and working with different lenders.
Understood. Thank you very much for your time.
Hey, Mark, this is
yes.
Scott. Well, why don't we take one more call? Unfortunately, we need to wrap up at around noon or so, but like I said earlier, we can go through the questions that were submitted and work with you guys as well to put together an FAQ for those questions that we didn't get to. But let's take one more question.
Yes, hi, this is Supriya.
Yes, Sophia.
I had a question which you might have answered, but it's still unclear. There's a question. It's clear that SBA 7A specifically excludes apartments. So my question was, did the caller who said they got approved with Washington, was it an apartment, a community, a property management company, or can one of the panelists answer this question? We keep hearing that it specifically excludes apartments.
So I think I can answer that. There is no exclusion for apartments. What there is exclusion for passive ownership of businesses. So many people own apartments as passive owners, meaning they're not actively involved in the management, don't have employees that are doing the management. They just own it as a passive investment. It is true that under 7A, and now the interim guidance says that those rules apply to these PPP loans. You cannot apply if you're a passive investor. But many apartment companies are not passive. They actually have employees that are working in the apartment and in the rental office, and they hire their own cleaning staff. Those would be small businesses that are eligible, can apply, and obviously, as you've heard, have applied. So there's nothing about the apartment industry that's excluded. It's just that passive ownership of property is excluded, and there is a lot of confusion around that. So I appreciate the chance to clarify that. Did I answer you, Sophia?
Yes, you did. Thank you. This is Supriya Sriraman. Thank you.
Great, thanks. All right, Scott. Well, you're right. I know. I apologize to those of you we couldn't get to, either that you submitted the written questions or if you've been waiting patiently to try to ask a verbal one. There are a lot of questions. I hope we've answered most of them. Feel free to use that email address in the slides, or contact me directly, or contact the NAA or other people at Womble, and we're happy to continue working with you. We're all figuring it out as we go, and I certainly appreciate you taking the time to attend the webinar.
Great. Thank you, Mark. Thank you, Sarah. To all the other folks at Womble, a big thank you, obviously, spending 2 hours today answering 173 questions. So obviously, very valuable information. We appreciate all your time. We also appreciate all the NAA members dialing in with their questions to hear this valuable information. As we mentioned earlier, we are recording this, so we will be posting this to the NAA site. We will let folks know when that is up and available for your review. So with that, thank you, everybody, and we'll talk to you soon.
Thanks, everyone. Bye-bye.